It is exactly 8:30, and welcome to week 2 of J150, Introduction to Criminal Law. Those of you who listened to the archive last week understand the expectations that I gave with the open house. As I said before, your lectures will take place on even weeks. So tonight is the first real lecture that we're going to do, and I'm going to, in an hour and a half, go over the PowerPoint and also the assignments for the week. So let's go ahead and let's get started. So I'm going to start out by sharing my screen. Okay, and you can see that I've already gone over those issues. So let's start with our week 2 announcement. Because these things on this side here, I covered my information, and then I covered all the additional course requirements. And then I remind you that the live lectures take place every other Tuesday, 8:30 to 10. Beginning today, which is April 11th, weeks 2, 4, 6, 8, and 10. So let's look at the announcement and see what the assignments are for this week. In week 2, we're going to discuss constitutional issues and elements of crimes, and you are expected to read chapters 3 and 4 of Shive and Shive Criminal Law and Procedure. I also sent you the PowerPoints earlier, sent them to you Sunday for chapters 3 and 4. And also, I sent you some additional information which constitute an outline of chapters 3 and 4 for your own information. We're also going to talk briefly about criminal law and procedure and the activities of Constitution and elements of crime. You should be aware of the fact that your discussion post is due tonight by 11:59 p.m. Central Standard Time on the topic of strict liability crimes. Many of you have submitted your initial posts, and I've already given you the expectations for posts. I spent a great deal of time covering that in the open house, so I won't keep repeating that. And then on Saturday, on the same topic, you'll submit your reply post by 11:59 p.m. Central Standard Time. Finally, your written assignment, you'll note this week that you have just one written assignment and a quiz. You do not have a project. You will have one next week, though, week 3. But at any rate, this week, cruel and unusual punishment and the quiz. And all these assignments, both of them, are due by this Sunday, 11:59 p.m. Central Standard Time. So make sure you do that. And then my motto at the bottom, start strong and finish strong. At this point, should be continue strong, because I already shared with you my motto. So now let's take a look at our course calendar real quick. Course calendar, of course, is very important you to follow. You will see that the reading assignment was Monday, which I already told you. Your initial post, the fact that we have a lecture taking place, your reply post, and then your written assignment, which I'm going to elaborate on in just a few minutes, and then your quiz. As you know, your quiz constitutes 10 questions. You have 10 minutes, and it is very important that you try to score as high as you can, because your quizzes constitute the only real test that you'll have in this particular course. So it would behoove you to score high on the quizzes. I've already recommended to students that you delay taking the quiz until the end of the week so that you've had a chance to get the materials that you need and an understanding so that you can score very high on the quiz. So now let's look at our module for the week. Let's take a look at the assignments again for just a minute. Your written assignment is what I said it was, cruel, unusual punishment, and you're going to take the facts that are given and the question, and you're going to write a 2 to 3 page paper. Remember, 2 to 3 pages. I already gave you a rubric for you to follow, and I recommended earlier that you use that rubric as a checklist to determine. Some students have submitted those papers without citations and references. Citations in the body and references at the end. It's not a or. It has to be both of them. And you should also have a cover sheet. You have the tools that help you with NoodleBib to help you to how to lay that out. And you should be familiar with that, as a matter of fact, by now. And then, as I said before, make sure you check your papers through Grammarly for plagiarism and submit them to me to make sure that you don't have a high percentage, because you will lose points for that. So very, very, very important that you read the question. Explain if you agree with David that the execution of minors violate the prohibition of cruel and unusual punishment found in the 8th Amendment. And then I also say explain both and why not the execution of minors. We're going to mention that a little bit tonight in the lecture. So that's the written assignment for the week. And then, of course, your discussion post on strict liability, and many of you have already submitted the initial post, which again is due tonight. Then your reply post will be due on Saturday, and I also encourage, as some of you have taken me up already on it, and reply to more than one post. It makes the discussion forum more interesting. And then finally, you have the quiz. Okay, so now let's go to back to the lesson. Oops, I hit that bell. Okay, let's go back to looking at the lesson. Okay, here we go. Okay, now let's look at the lesson content. First, it gives us the objectives, and the objectives is basically what you can expect to learn from this week. Constitutional issues, the elements of crimes, and we're going to cover how crimes are classified. Again, your assignments, which I already gave you and it told you what to do. Now, these are not written assignments, Constitution and elements, but these are the written assignments. This, and this. So you got your discussion post, your written assignment on cruel and unusual punishment, and then your quiz. Okay. So now let's look at a little bit of this. So what are we talking about? Constitution and the elements of crime. Well, you're gonna read these, and it's going to help you. We're going to be talking about this case, Marbury versus Madison, which is a Supreme Court case that kind of set the stage, and when I start the lecture in just a few minutes, I'll cover that. We're going to talk about federal versus state law and how it applies. And then the Commerce Clause, Article 1, Section 8 of the U.S. Constitution and how that applies. That's it right here. And then we're going to talk about the First Amendment. The First Amendment, many people are familiar with the First Amendment. It contains issues of speech, press, religion, and assembly. And so we're going to talk about some of the things that are taking place even now. And I'll share with you some things that are coming up the pipe now. Finally, we're dealing with cruel and unusual punishment. Pretty much we're going to be dealing here in this section with the imposition of the death penalty and punishment, and we're going to talk about the issues of the death penalty as applied to juveniles and adults and how that works. Strict liability, you already should have a clue on that, because that has to do with your discussion post for the issue about the driver's license that the person is driving on and didn't know they were suspended. So you want to take a look at that information as well. Parties to a crime and principals and accomplices. We're going to talk about those kind of things, accessories and all those. And then you have this little exercise down here. And you're going to drag and drop. So you're going to look at some of these things. And so the first one asks the question, what is a retroactive law that criminalizes an action that was legal at the time and when it was performed, or it increases punishment for a crime after it was committed? Which one of these is the applicable one? You can type in the chat box, and I will see that. Which one is it? Which one of these answers is it? Anybody know? Ann, or anybody else that's on in the class now? You want to type in the answer of which one of these it is? A lot of times students are reluctant. She says enumerated powers. Okay, a retroactive law that criminalizes an action. So I'm going to go with your answer. I know what's going to happen. That's not it. I'm going to take one more shot before I give you the right one. Remember, retroactive law. A law that is retroactive. Retroactive means in the past or after the fact. Want to take another shot? Yep, I gave it when I said that. Ex post facto is the correct answer, after the fact law. So these are good to get you ready for the quiz as well. Governmental powers not explicitly stated in that government's constitution, but fairly implied by it. There it is. There it is. And the one that you had, enumerated powers, it goes with, let me read down here. Person who has knowledge, person who has assist, mental, parties whose conduct involved. Here it is. That's it right there. Government powers explicitly stated in the Constitution. A person who voluntarily unites with another in the commission of an offense. Which one? What do you think? Okay. That's what a lot of people pick. How about this one? Here we go. Accomplice. That's the right answer. The one that you pick, that's the one. Accessory before the fact. Person who aid or assist in the commission of an offense. But a lot of people get that confused. So, you know, again, these are good to help you. The state of mind to do something prohibited by law without necessarily intending to accomplish the harm that results from an illegal act. There we go. You're right. And persons whose conduct involve directly participation of the crime. It's only a couple left. Okay. Persons, parties whose conduct involve direct participation in a crime. You said accessories after the fact? Nope. How about this? Parties whose conduct involve direct. When you see direct participation, then you're talking about principles. The mental purpose to accomplish a particular thing. It's only 2 left. Specific intent. And then, of course, accessories after the fact. So these are good little things to do, and you'll see these from time to time, so you want to do these things. Okay, so they will help you a lot. So having gone through that, I'm going to leave this, and I'm going to go back now to the lecture. Let's get going. So let's talk about what we have here. In Chapter 3, the constitutional limitations on the prohibition of criminal conduct, Shive and Shive. So you want to focus in on the things that are relating to the constitutional limitations. And so I'm going to kind of take you through them. So, and then as you have questions, feel free to type in the chat box, and then I will see them. So, okay, judicial review. What is judicial review? Okay, we have 3 branches of government. We have the executive, which is headed, I'm talking about on the federal level now, is the president heads the executive branch. The legislative branch is called Congress, which consists of the House and the Senate, U.S. House of Representatives and the United States Senate. And then there is the third part, which is the judiciary, or the courts. And it is the courts who have the power and authority to interpret the laws that are passed by Congress, signed into law by the executive branch, and then, by the way, in your state, the executive branch consists of the governor, the legislative branch consists of your House and your Senate in your various states, and so then you have the trial courts, then you have the appellate court or the Court of Appeals in jurisdictions where you are, and then you have a Supreme Court, that's a state court. So, but in our instance here, the judicial review. Now, in federal cases, the judicial review generally at the trial level is called the U.S. District Court. That is the trial court. And then you have what we call the Court of Appeals. And there are various circuits. I think there's 9. I think I'm right. I think it's 1 for each justice. And so the circuits Court of Appeals is the level where district court cases are sent to oftentimes. Sometimes they go straight from state court cases to that. They don't go to the district court. But just not to confuse you, the starting level for federal cases is the district court. And then you have the U.S. Court of Appeals. And then the final court is what we call the United States Supreme Court. And, you know, I always tell students, whenever you're specifically writing or addressing the issue, and you say to me, appeals court or Supreme Court, I ask you, I don't know what you're talking about, because you should always be specific. If it's the federal level, you're talking about the U.S. or United States Supreme Court. Or if it's the federal level on the appeals court, it is the Court of Appeals, the U.S. Court of Appeals. So you want to make sure you specify. If it's a state issue, you want to say that whatever the state is that's involved there. Anyway, so the judicial review. So the government has a check and balance, and it says specifically that the purpose of judicial review is to limit the power of the government. And so the famous case of Marbury, it says Marburg, but it's really Marbury versus Madison, 1803, says that the courts interpret what the law is. And they can, as it says, strike down legislation that is unconstitutional. As you know, the executive branch does things, and then there are appeals to the courts. Well, just like, for example, President Trump has issued these executive orders on these travel bans, and you know what has happened already is that the district, not the district court, but the Court of Appeals in the various area, sections have challenged it. Well, ultimately, when there is some conflict, it can ultimately be appealed by the parties all the way up to U.S. Supreme Court. And so that's likely to happen. And so now, as you probably should know, the Supreme Court of the United States consists of 9 justices, and just yesterday, the 9th justice was put in to complete the term, or rather to take the place of Judge Anton Scalia, who passed away a little over a year ago. And so now they finally have appointed the new justice. So now the court is at full speed. Now, whenever you see a law, just so you know, and you look at it, always be curious about what the vote is. Be aware, and this is some extra stuff for you, if it's 5-4, that means that one change in a justice in the future can possibly change that. It's said now that there are 4 liberal judges, 4 conservative judges, and 1 swing judge. That's the way that it's presented now, which means that that swing judge is generally considered the one that can take it to victory or defeat, depending on how they vote. So the further you get, so if it's 6-3, then that's probably going to be stronger. If it's 7-2, it's going to be even stronger. If it's 8-1, oh, it's going to be real strong. And then, of course, it goes without saying if it's 9-0. So anyway, it's the courts who look at and say this is constitutional or not constitutional, or can strike down the laws saying that it's unconstitutional. Okay? Let's go back. Now, I already told you this, so I'm not going to go over this. So this PowerPoint just basically says how the law come about, talks about the executive, legislative. Now, be aware, Congress, though, does not have what we call plenary legislative authority. What that means is Congress does not tell the states what to do. Generally, the states have their own independent rights. However, if there is a conflict between a state law and the federal law, then the federal law will take place, particularly if it's in our United States Constitution and deals with a federal question from the U.S. Constitution. So U.S. Congress doesn't control that. Each state legislature controls every state in the Union except the District of Columbia. Okay? And then there are powers of Congress that allows Congress to pass laws, such as you're familiar with the Patriot Act. You're familiar with what's the name of that law? RICO, the Racketeer Investment Act. It's another part to it, but I can't recall off the top of my head. But you'll run across it. And I think crime is with the C organization. So anyway, the bottom line is that the federal government passes these laws. You're going to see the federal government passes clean air laws and all kinds of things like that. And then when there are things that cross state lines, such as air and water and those kind of things. The Commerce Clause, as I referred to a little earlier, deals with, as I said, interstate commerce, economic activity between the states or more than one state is affected. So that's kind of like, let's say, for example, we're in Illinois, and so in the Chicago area, we have Lake Michigan. And Lake Michigan also touches on Wisconsin and Michigan as well. So, and then you got other bodies of water, like the Mississippi River, which runs up and down, all the way from up in St. Paul, all the way down to the Gulf of Mexico and runs throughout the country. Well, the federal government, through the Interstate Commerce Clause, control the laws that affect those moving bodies of water. Congress has relied on the Commerce Clause to enact criminal laws. I just told you that a few minutes ago. For example, here's an example here. It says, Congress can't prohibit prostitution, but it is a crime to transport persons across state lines for moral reasons. That's called the White Slave Act, where a person is transported across state lines for sex and prostitution. But each individual state has the right to legislate prostitution, which incidentally, some students think that Nevada and Vegas has legalized prostitution. That is not true. That is not true. I thought that for many years. Ann, I want you to change your setting to when you type it in that says not privately, but to everyone, so that if someone else comes in, then they can see it also, because in terms of participation. So change your setting on your chat box where that arrow tells you to click on everyone, and then I'll see that when it pops up. So Congress has broad authority to enact these laws to deal with crime across state lines, wiretapping, and things of that nature. So, okay, there, you got it. Thanks. Then let's talk about treason. Okay, treason. You know, you don't hear a lot about it. You won't hear a lot about treason because it's not really a law that you hear people be convicted for. There are some others that are close to it, which we'll talk about in a minute. But treason, it says, involves betrayal of one's country. And the most heinous crime under common law. But the reason why treason is not so much used is because during what we call the McCarthy era, which goes back to the 50s, anyone who felt like you were not going along with what the government was saying, they'd call you a commie or a treasonous person. But because it's been abused to try to punish people who go against or political dissenters, which we allow in this country, thank God, for people to disagree and present their positions and form a protest, which we'll be talking about in a little while, then in that case, treason doesn't come about too often. So the Constitution sought to limit the power of the government to use treason as a tool to punish dissenters. A person can only be punished for treason if they acted to levy war against the United States or in adhering to the enemies of the United States. Now, some people might say, well, what about if you sell government secrets and things like that? That is akin to treason, but what we do is we make sure that those individuals are prosecuted for selling those crimes. There's a guy named, I think his name is Edward Snowden, who dealt with some government secrets and stuff, and then he fled the country to be sanctuary in a place where the United States can't get him back here. And then there's been some instances of military people who've done the same thing. But let's talk about these two things. You don't have to worry about them, even though we already talked about ex post facto laws. They don't really exist because of the fact that they violate the Constitution. Both violate the Constitution. A bill of attainder is an act that the legislature passed imposing punishment without a trial. So in other words, you don't have your due process rights to a hearing and to face your accusers. We don't have that in this country. So we've done away with that. The ex post facto is a law passed after the act violates the principle of legality and says you should be on notice of a law that exists on the books when you commit an offense, and that if you commit the offense and it was not an illegal act at that time, it cannot be. Here's the deal. Here's what's going to happen. I give you this example. And this Illinois is just getting ready to do it. They're following the lead of Colorado. I just was reading yesterday that there is a bill right now that's in the Senate or the House anyway to pass a law allowing marijuana for recreational uses. They already did it for medicinal purposes, but they're getting ready to pass laws allowing that and to decriminalize marijuana. Of course, that's a thing that's happening all across the United States of America. Some states haven't gotten that far, but it's going to be just a matter of time. So here's what I'm getting ready to say. So let's say, for example, if they make that legal and then you're caught, well, then of course you're not going to be prosecuted. But let's just say it is legal, and then they make it illegal again, and then you get caught. They say, well, wait a minute, we're going to prosecute you on the law that existed before, where it was illegal, even though it's legal. Well, the fact of the matter is that it's going to be based on the time that you committed the offense. That's the key thing. That's the key thing. And we're going to give a couple of examples. The bottom line is this. All you have to do is remember what it means. Ex post facto. It means after the fact laws. So that means after you've done something, they pass a law to make it illegal, even though it was legal at the time you did it. It can't be used, and you can't be prosecuted for it under our U.S. Constitution. That's all it means. Or they can't change a law to add some things. We're going to go over that in a minute. For example, here we go, right here, Carmel versus Texas, where the Supreme Court reversed this case because at the time of this offense, Carmel was charged with sexually assaulting his stepdaughter. So at that time, 1991 and 92, Texas had a law that stated that a defendant could not be convicted merely based on the testimony of the victim unless she was under 14. Well, Carmel had been convicted under an amendment, so they amended the law. After he had done, in fact, they amended it. It was an ex post facto, so it was a law, an amendment that took place after. So it's pretty clear, all right? So I'm not going to elaborate too much on that, more from there. The Bill of Rights, there are the first 10, but these are the main ones here. The First Amendment, freedom of speech, religion, press, and assembly. We're going to talk about those a little. The Second Amendment, the right to bear arms, which is a very hot topic with a debate about gun control. The Fifth Amendment, you don't have to testify against yourself and those kind of things. The Eighth Amendment, dealing with cruel and unusual punishment, and then we will discuss the death penalty concerning that. And then the Ninth Amendment are rights that are retained by the people that should not be taken away because the Bill of Rights says they have those rights. We're not going to touch much on that. You really won't deal with that too much in our criminal justice field. You'll deal with primarily these first ones. So what happened is that originally the Constitution, when it was written, did not have the amendment. The amendments came in to take and apply the law further from the federal level to the state level. So the 14th Amendment in 1868 provided a justification by extending the Bill of Rights to apply to the states. So now all those Bill of Rights I just showed you as of 1868 apply to the state. And then, because of the due process clause, they require that you have a chance to face your accusers, prepare a defense, and those kinds of things. So both of those came about with the Bill of Rights being extended to the states because of the 14th Amendment. Okay. This is just some historical stuff. Now, Cantwell, this is an example where dealing with religion and how the courts are very protective of religion in most cases. The Supreme Court struck down a state law that prohibited door-to-door solicitation for any religious or charitable purpose without prior approval of the state agency. Well, these people were Jehovah's Witnesses, and they were stopping people to share their beliefs. Well, they were convicted because they didn't obtain approval. The court said, no. This attempt to use a breach of peace is a violation of the First Amendment, and that as a result, you are really aiming at not allowing these people to get out their message, which is part of your protection under the First Amendment. And so the Supreme Court ruled in favor of the Jehovah's Witnesses, Cantwell. So the First Amendment, as I already said, deals with freedom of speech and press. Now, there's one of the things that you should be aware of. Not all speech is protected. Lewd, obscenity, libelous, profanity, insulting, or fighting speech. Now, you're going to find that it depends on how those things are used. You're going to discover when you look at obscenity that there's a court case that we'll discuss that involves allowing obscenity to be released under certain circumstances, but it's controlled. Also, you cannot create a situation that's dangerous. Like, for example, there's an old case that said you can't yell fire in a crowded theater. What that means is that you have a free speech to say it, but because you're saying that could create a hazard and stampede resulting in injury and death to many people, the First Amendment will not protect that. So what it will say is the right to protect the public weighs more than protecting your First Amendment right to say that. And so those kind of things. Imminent lawless action, and we're dealing with situations where you're speaking out of something to create a riot or create a battle or something along those lines. In that situation, then you cannot get away and do those kinds of things. That is going to violate the First Amendment. Okay. For example, in Schenck versus United States, the Supreme Court upheld convictions of some people who were saying that the First Amendment allowed them to mail leaflets attacking the American participation in World War. Well, Schenck stood for the proposition saying that the First Amendment does not protect that because it created a clear and present danger for the troops because they were actually in war at that particular time. Now, there are instances where people can protest and pass out their material to protest the war and and those kind of things. But you have to find yourself in a situation where you have to make sure that you are protecting the rights of people constitutionally to be able to do so. But when it creates a danger for the troops, then the Schenck case applies. You could easily get confused here. So all I'm going to simply say to you is that when the Schenck case came out, we hadn't had a lot of the protests that were taking place, like the Vietnam War, the Iraq War, the Gulf War, and all these other kinds of things. But the point of the matter is that individuals find themselves in situations where they are allowed to speak as long as it doesn't create a clear and present danger to people. Hess versus Indiana in the Supreme Court reversed the conviction of Hess because the speech he gave did not constitute imminent lawless action. Now, listen to this, and you'll see the point in a minute here. This person was convicted for yelling, "We'll take the," and I don't use that kind of language, "the effing road street later," during an anti-war. Now, he was saying that. He said that out loud. So the court said, well, we can't convict him because it's not constitutional imminent lawless action, because the court said that his speech was not directed toward any individuals or a certain group. That's when you get to the imminent lawless action, when you're doing something to incite a group or individuals. You run into that. And just because he said that, and people were offended by hearing it, they said he had a right to still say that without being prosecuted because the First Amendment gave him free speech. Let's talk about symbolic speech and expressive conduct. It's quite clear in the United States of America that people can protest, present their speeches, share their information, and then you can use symbols like armbands, and then flag burning. Flag burning of the American flag is protected by the First Amendment, as long as you're not burning somebody else's flag. Now, there are some situations and circumstances where that could change, and the reason why that could change is because of the makeup of the court. But it's not likely. I don't know what the vote was in this Eichmann case, but I can tell you this, that I have heard of some state situations now, or some lower level federal courts, where there's some possibilities that there's some challenges to this kind of thing. However, at the present time, it's still protected under the First Amendment. You might not like it. Somebody might say, oh, that's unpatriotic. Well, it may be, but it's their right. For example, there are organizations that we don't agree with, like the KKK, the Nazis. People can march and present their positions, and even if we don't. Now, what happens is that, like, for example, I know of an instance here where the KKK wanted to do a march in a primarily Jewish community called Skokie, Illinois. Well, they had a right to go and protest and march, and the protection had to be provided. They had to go in and let the authorities know, and why? So that they can provide protection for them. And so both sides, the people who were anti the KKK and the KKK, were allowed to express their position. There's an old saying in the First Amendment that if we stop the KKK from putting out their positions, then we're one step closer to censoring ourselves on positions that we want to present that's not popular. So that's the key thing about the First Amendment. So peacefully, as much as possible. Public speech that threatens the public peace can be punished. And I already told you about Cantwell. Fighting words. Remember when it's directed at individuals, face-to-face, and that kind of speech. Hate speech fits that. Obscenity, profanity, when it creates that kind of situation and it creates imminent lawlessness and you're inciting people, such as trying to deal with, here we go, the United States Supreme Court reversed the conviction of Gregory Johnson for flag burning. Now, Johnson burned the flag, and I remember when this happened, outside the Republican National Convention in 1984. The court argued that he was not convicted for flag burning, but rather the message he was conveying. See, so burning the flag is a message. His message is protected under the First Amendment. Thus, flag burning is okay. Now, you got to make sure it's your own flag, because otherwise you could be charged with criminal damage to property. Virginia versus Black is a case that deals with trying to incite people. The U.S. Supreme Court held that states may punish individuals for burning a cross with the intent to intimidate. This person, Black, was a Ku Klux Klan member, burned a cross during a rally nearby highway with the intent to intimidate people. In that case, then we're talking about hate crimes, and that will not be allowed. Free exercise clause of the First Amendment. So that gives you a right to peacefully assemble in public places. As I said earlier, the government may impose the time, the place, and the manner. And the reason for that is not to control your presentation, but to provide order during the time of your protest or demonstration. Free exercise of religion. The courts try to stay away from interfering with religion, except when it engages in a threat to the public health and safety. The Tennessee Supreme Court upheld the validity of a statute making it a crime to handle poisonous snakes. Well, why? Because poisonous snakes represent a public health threat. There was in Indiana a court, there still is. There is a church. It's called the Cannabis Church, and you can look it up. And it's Cannabis Church of Indiana, and it's a legal church that operates. However, use of cannabis is illegal in that state, but they will not interfere with your religious activities. However, if you participate in using that and then you leave there, then you will be prosecuted for driving under the influence or being under the influence. So it's kind of they're not interfering in your service, but what you're doing is you're creating a possibility until it becomes legal in that jurisdiction. And then as far as there are some people whose beliefs don't believe in medical treatment. But if you are a parent to a child, you cannot refuse it for that child. A guardian ad litem will be appointed for that child because that child does not necessarily have to take the same position. You're an adult and you can take the position that you don't want the treatment, but you cannot decide the same for your children. Well, it's on our religious beliefs. They say, so what? No, because it's a danger to those children, and those children need to be given the opportunity to get to the age where they can make their own decisions. Here's an example where there was an attempt to end a protest. The United States Supreme Court upheld the right to peaceful assembly in a public forum. U.S. Supreme Court reversed the breach of peace conviction of 187 African-American college students who participated in a peaceful civil rights demonstration. Well, they said that they were disturbing the peace, but in reality, the Supreme Court says, no. They weren't breaching the peace. What you're trying to do is censor them from the message that they were trying to present, and they were doing it in a peacefully fashion. So it said, no, that violates the First Amendment of the Constitution, freedom of speech and assembly. Yoder versus Wisconsin, or Wisconsin versus Yoder, is kind of like a moot case. But back when this case came out in '72, where the Supreme Court ruled that compulsory education attendance could not be forced on the Amish, because the Amish wanted to be to themselves. Well, they said that this violated the free exercise clause of the First Amendment of the Constitution and imposed a restriction on the exercise of the religion. And it was really, really, really what they were doing. Well, of course, now that's no big deal because compulsory school attendance laws have changed a lot with the advent of homeschool, because now people are able to homeschool their kids. As many are. I have one of my kids that we homeschool. The other thing that takes place in those kind of cases or situations is individuals are able to, for example, challenge the draft as conscientious objectors. Well, we do have a selective service, but it doesn't operate the same way it did in the '60s, where there were people who went to Canada and so forth and so on. But, like, for example, the example was Muhammad Ali, who at that time was called Cassius Clay. He didn't want to go in the military because it violated his Muslim beliefs. So it went all the way to the United States Supreme Court, and the Supreme Court sided with him and said that he should not have been convicted as a criminal and that he should not have been stripped of his titles or any other things, and was reinstated because of the fact that it was a violation of his religious beliefs. But you got to be certain of this. You can't use it as a sham. It has to actually be one that you're really basing your religious beliefs on. Okay. Let's talk about some things relating to that. Now, here's a case we call the peyote case, employment decision versus Smith. Well, the Supreme Court rejected the claim that the Native Americans said, oh, we use peyote in our worship services, kind of akin to what I just said about the marijuana, and said that's a free exercise of religion. And since peyote is a hallucinogen used in the sacramental ceremonies, the court said that religious beliefs do not excuse people from complying with the laws or the neutral laws that everyone else has to obey. So you will be prosecuted for this, because just because you're a Native American using it in your ceremonies, it's still illegal, and so therefore you can be prosecuted and you can lose your job or position, as in this case here. And that goes to the same as I was talking about, that cannabis court as well. We call that the famous peyote case when I was in law school. Now here's one that is very interesting. The Church of Lukamai Babalu Aye versus the city of Hialeah. It took me several quarters before a Desmond Doss. What's the Desmond Doss? I'm not familiar with the Desmond Doss. Clarify that for me. Yeah. What's the Desmond Doss? So I'll come back and have you clarify that. But in the meantime, I'm going to present this point here, is that it was a war hero that refused to bear. Oh, you're talking about a Desmond Doss as a person. Is that what you mean? Oh, okay. Yeah, but it has to be based on some kind of legitimate religious belief. You know, that was there was another military person with the same position, but that kind of fits in that category. Yes, it does. The answer is yes. Yes. Yeah. If it's religious, then those are the kinds of things. I'm not familiar with that particular instance, but those are the kind of arguments you'd make, is that, well, I'm a conscious objector the way Muhammad Ali did, because it is at the heart of my beliefs that I'm not to participate in a war and kill people and hurt people, and that's probably the same thing. So the answer is probably yes. Okay, but let's talk about this case here. And this is very interesting. The Supreme Court upheld the right of the church to make animal sacrifices. Now, that's right. That's right. The Supreme Court of the United States upheld the right of the church to make animal sacrifices. So people could, in this particular faith or belief, they could do animal sacrifices. But in the city where they did this, there was an ordinance that imposed on the church unnecessary killing, tormenting, torture, or mutilating an animal in a public or private ritual or ceremony, not for the primary purpose of food or consumption. But the court came back and said, this is an unconstitutional ordinance because it violates the right to practice religion. Now, animal rights people might not like this, but I'm going to ask you, do you know why this, and I haven't read this case in a long time, but I think I remember it, it's in there. There's a reason why they allowed animal sacrifices in religious ceremonies. Do you know the reason why that is? Remember, the courts don't like to attack religion. So, what do you know, or do you know? If you don't, I'll tell you about animal sacrifices and religion. Okay. In the Bible, in the Old Testament, that's how people made their repentance to God, in animal sacrifices. And they would sacrifice doves and all kinds of animals and things like that. And so that's why it is, because then it hits right in the heart of some biblical principles and what the Bible speaks of, even if a person doesn't believe. Same thing with the Quran or other beliefs as well. The point of the matter is that it's at the core of many religious activities to be able to offer animal sacrifices. And the Bible is one. And I know all about that because I am a Christian, but I'm also a pastor and have been a minister for a long, long time. So that's the reason for that. So what am I saying? What I said earlier is that unless there's a public safety issue, then they will allow it. The peyote, they wouldn't allow. But the killing of animals as part of the religious ceremonies, they would allow it because of what I said a few minutes ago. Now let's talk about the Second Amendment, the right to bear arms. There are so many issues involved with that, and I'm not going to, yeah, I know, because you're an animal rights person. But be aware of this, is that many mainstream religions today don't use animal sacrifices anymore. But there are some Old Testament religious churches or organizations that do still follow the practices of the Old Testament. In the New Testament of the Bible, we don't do that. We don't do that in our church, for example. Matter of fact, quite often, the only time really you hear of it is in witchcraft or something along those lines. But in mainstream religion, you don't hear that as of now. So it's not really a big issue anymore there. But that's the reason why, if you have those people have those beliefs based on the Old Testament. I had a cousin, he was stuck in that Old Testament stuff, and he believed in that stuff. But I agree with you. So the right to bear arms, excuse me, there's a big conflict. And the question about what the Second Amendment was intended for, and people believe in having guns. And so because there's such a powerful lobby in the United States called the NRA, the National Rifle Association, the right to bear arms in the Second Amendment is kept out on the forefront, and is anti-gun control. Any kind of gun control, they try to fight against it because they said it's a constitutional right under the Second Amendment for people to bear arms. Now, I'm not going to get into the debate, but I can tell you that if you take my constitutional law class, when I teach it, I've taught it a couple of times, I discuss 1 week. That's all the whole module is about this issue. But the bottom line is that the issue of right to bear arms generally involves where you stand in terms of your experiences in life. I have submitted that in the urban areas, gun control is really, really, really important because of the use of guns on a regular basis, and that the murder rate and deaths of individuals are pretty high with the use of guns. In the outlying areas or the suburban areas or the rural areas, then you find more people who want to have their guns. And so now we have laws that allow you to carry and conceal, but you have to register your guns. You have to pass the background checks and all of that, which we'll be talking about in a few minutes. Okay. In Columbia versus Heller, Supreme Court held that the District of Columbia ban on handguns is unconstitutional. Heller had applied for a handgun and was denied the request by the Federal Judicial Center, which cited strict gun control ordinances in the district. Well, the Supreme Court reversed that, saying that the ban on handguns is unconstitutional. We had one in Chicago, same kind of thing. But I'm telling you why. Even though the courts are supposed to be different from the legislature and the executive branch, the NRA is very, very powerful in terms of lobbying, in terms of those kinds of things. But there's still some restrictions. I was just told recently that President Trump rolled back the requirement that a person does not have to be checked for their mental capacity to purchase a gun. That, to me, is ridiculous. I don't care what side you're on. Second Amendment, that. Also, there's another class that I teach, critical issues in criminal justice, J150. I'm teaching that right now, where we allow that. So, but yeah, I think it's so wrong to have people who are mentally, not have them checked to see, So, like, for example, right now, there's a dude right now that you've seen the news, they're looking for. He's supposed to have guns, and he's threatening the president. I don't agree with a lot of things that the president has done, but I'm not going to try to kill the man because that's not right, first of all. And then secondly, that's not the way we resolve our issues in this country. It shouldn't be anyway. So, but yeah, it's bad because we need to watch out for those kind of things. Now, here's an example of why I said that. Going back to the Brady Act of 1994, and it's interesting that he would roll back that kind of thing because what I'm about to talk to you about happened involving the Republican administration. Jim Brady, who was the former press secretary of President Reagan, was shot in the head by a guy named Hinckley. He just recently got out of jail. And Brady remained paralyzed for life, and then he passed away. Well, Hinckley had a criminal history. Now, and then there were some other issues, too, with him as well. So the Brady Act came out and said it requires background checks before someone can purchase a gun, which is good. So not only should you check the background, but the mental capacity of that individual should be. But our president has said nope, and that's taken out. So that's kind of like, what? So I'm with you in terms of that. Whatever side you're on, it doesn't make any sense. You almost all the time hear people with guns, just like you heard this man took his gun, went into the school where his wife, who is married to, separated, shot and killed her, wounded a couple of kids and then took his own life. That was a gun. Columbine. We can go on and on. Sandy Hook. You can go on and on and on, and there's so many of those situations. But anyway, opponents argue, oh no, he died. Oh God. See, that's what I'm talking about. Yeah. I did not know that. I am so, that touches me. He was 8 years old. I got an 8-year-old daughter who will be 9 coming up soon, and I've got grown kids who were 8 at one time. And grandkids who are around that group. That's tragic. But that's what I'm talking about. That is what I'm talking about. There's always an uproar. Yep, it is. It is heartbreaking. There's always an uproar after something like this happens. But you know what I told people? Somebody says, well, guns don't kill people. People kill people. Yeah, but guns are easy to use than a knife. Easier to use than a knife or any other weapon. And also, innocent individuals, like that young kid, he was not intended to be a target by this man. He was intended on killing his wife and himself. But look what happened. So, yep, absolutely. Opponents argue, now listen to this, opponents said that the Brady Act is unconstitutional because its provisions requiring local law enforcement officers to conduct backgrounds violates the 10th Amendment, which is, they say, the right to be retained by the people. That's stupid saying because a 2-year-old can operate a gun. Yeah, I hear you. I hear you. I am against guns because my natural parents, I shared the story already with you guys about what happened to them, but my adopted parent, who later on raised me, she was the victim of a handgun shooting and almost lost her in 1971. And so I spoke and did an editorial for television about the damage that handguns does to people. So I'm out here in the suburban areas where there's, really, I was at a session at our campus in Romeoville that was not sponsored by our school, but it was sponsored by a legislator in Illinois, and she had the state's attorney's office to come out and explain the new carry conceal law. Illinois was the last state to allow carry conceal. Other states had it, all 49 other states had it, but Illinois was the last. And one of my classmates who went to law school with me worked very diligently to try to fight against guns. But anyway, what I'm getting ready to tell you is that when I was at that session, it was kind of like the Hatfields and McCoys. When I say that, it's a historical thing. It has to do with the borderline of, I think, Kentucky and Missouri. But at any rate, the point is that on one side you had the people who were the gun control people. On the other side of the room, you had the people who were opponents of that and believed in guns. And so the issue was very volatile. It was a very volatile debate. So, but anyway, the Supreme Court agreed but upheld the Brady statute overall. They agreed that it might violate the 10th Amendment, but overall they said it was a good law. And that's a good thing, because the fact that there ought to be background checks. My goodness, come on now. Let's get real about this. So, the void for vagueness doctrine and overbreadth. I'm going to just talk a little bit about that. The Fifth Amendment says, no person shall be deprived of life, liberty, or property without due process, which means you have a hearing, you have an opportunity to respond, you have an opportunity to get information, to defend yourself, and those kind of things. Laws that are vague, they fall on their face for what we call void for vagueness, which says that the law has to be clear enough that the person can understand. And it should not be overbroad so that it violates the First Amendment rights. Here's a few examples right here. Coates versus Cincinnati, the Supreme Court held an ordinance as unconstitutional because it said that it is a crime for 3 or more people to assemble on any of the sidewalks and conduct themselves in a manner annoying to persons passing by. Now, first of all, number one, what does it mean, annoying to persons passing by? Isn't that a relative statement? Just because it annoys one person, it may not annoy another person. So that's a relative statement. So, so it might annoy, for example, says it is a crime for 3 or more persons to assemble on any of the sidewalks. Or by the bus stop. When I went to high school, see, we didn't have, we still did. We have the buses to pick us up. We didn't have the buses. We catch the bus, a public bus. But here in the suburbs, here, my kids catch the bus on the corner. And there's more than 3 or 4 people standing at that corner. And sometimes they're laughing and talking and stuff. And there are people who live in front of them. The point of the matter is that is there going to be an ordinance that says that this is a crime for these people to do this? Well, the court said that the law was vague and overly broad because men of average intelligence will have to guess it. What does this mean? So it's not clear. So if you violate the law, it should be clear that you violated the law. Okay. A lot of times there were attempts like this next one, which I'm familiar with. Well, it's not in this one here. Maybe it's the next slide. Maybe it's the next slide. No, maybe not here. It might be further down, but if not, there was a case that Chicago attempted to control the gang activity by passing laws that said that same kind of thing, and the court said, no, we know what you're doing. We know you're trying to get to them, but you can't use that as a basis. So anyway, it violated the First Amendment right of people to assemble. Now let's get to the freedom from self-incrimination. No person shall be compelled in any criminal case to be a witness against himself. You know, when I was a criminal defense lawyer for many, many years, many times I didn't put my clients on the stand for a number of reasons. One of the main reasons is because they had a record. And if they had a record, they could be questioned about that record on the stand. So if they weren't put on the stand, they couldn't be forced to testify, and the prosecution cannot consider that as evidence, like you in your mind as a juror say, well, I guess that person didn't testify because they're holding something back. Well, that's probably true, but constitutionally, you can't use that as a basis in the law to determine whether that person was guilty or not guilty. Okay, in real life application, we know how that works. So anyway, a person has a right not to testify, just like the Miranda rights. You have a right to remain silent, and they give you those rights. Anything you say can and will be used against you. Well, those kind of things. You don't have to speak. You can remain silent. You have a right to remain silent. Anyway, it limits the degree to which the law can be passed that can write statutes that require persons to report information to the government that can place them in jeopardy of criminal prosecution. Now, here's an example of one right here. The famous Timothy Leary. Timothy Leary was what we call him? A drug doctor. Now, he wasn't a doctor, but he uses marijuana a lot. Okay, so anyway, if you ever go back and listen to the song Hair, you'll hear him talking about Timothy Leary. But ask your parents about that kind of thing. But anyway, this is in '69. This is when I came out of high school, okay, before most of you guys were even born or thought of. Anyway, the United States Supreme Court reversed the conviction of Leary, stating that there was a law that called the Marijuana Tax Act, violated his Fifth Amendment against self-incrimination because the court said that the Marijuana Tax Act required Leary to identify himself as a criminal. At that time, possession of marijuana was unlawful in every state, but we already talked about how that's changing. But the point of the matter is that at that time, he didn't have to, he would get prosecuted for not indicating that he had paid the Marijuana Tax Act. Well, as soon as you start to pay the Marijuana Tax Act, now you're admitting that you are violating the law. So they said, we can't force people to do that. So that law was declared as unconstitutional and a violation of the right to self-incrimination. Cruel and unusual punishment. The Eighth Amendment applies both procedurally and substantive law. You will discover that when we get to discussing the death penalty, that there's what we call a bifurcated process. In a case where a person qualifies for the death penalty, you will find that there is a determination of guilt or innocence, and that if that person is innocent or found guilty, forget the innocent. If they're innocent, they let go. But if they're found guilty, then the jury has the opportunity to consider a second hearing to determine whether or not they will implement the death penalty if the prosecution asks for it. Anyway, often applied to challenge cases of death penalty, as I said, can be employed to limit the definitions of crimes. Now, for example, in Rasmussen versus California, the court struck down a law that made it a crime to be addicted to narcotics. Being addicted to narcotics is an illness, and so if there was a law, and there was in California, and it's amazing that they'd have a law like that in California. California is like whatever goes, pretty much. But at any rate, the fact of the matter is that if you were addicted to narcotics, you could be arrested. Well, it was determined that that was a status. It's just like in status situations, like for example, why should we prosecute a person addicted to narcotics? Because that person really, it's really an illness. We don't prosecute people for having a cold or any of those kind of things, so why should we do that? So that's kind of like the rationale for that. But let's move right along here and get more into it. Before I talk about this, the famous case of what's the name of that case? I knew I had it in front of me, but I moved it off of my desk. I'll come back to it. Well, you cannot, the death penalty is legal. It is illegal. It is not unconstitutional. It is not a violation of the rights of anyone. So you can prosecute a person for the death penalty. And so since that is the case, it just came back to me. Furman versus Georgia. The case of Furman, F-U-R-M-A-N, versus G-E-O-R-G-I-A. That's the famous case that dealt with the Supreme Court and with the fact saying that capital punishment was okay. Now, many jurisdictions, including Illinois, have done away with the death penalty, period, because there are flaws, and you know why. With the inclusion now of DNA, it's been proven that there are so many people on death row who really didn't commit crimes, and so there was moratoriums. Originally, Illinois had a moratorium, and then finally our former governor, Pat Quinn, came and issued a ruling saying the death penalty is done away with in Illinois. Pat Quinn, I knew very well. He was my classmate in law school. But anyway, moving on ahead, we do not execute juveniles. The Simons case, the Roper versus Simons case, held that the execution of juvenile offenders is a violation of the Eighth Amendment, cruel, unusual punishment. And so there were two justices, one who passed away, Scalia, and Judge Thomas, who I never agreed with any of his rulings, dissented saying that the court was legislating from the bench. They didn't want to pass on it. But the point of the matter is that it is the law of the land that we don't execute juvenile offenders. Now, even before that, some states did execute, some didn't. Our state, Illinois, did not, because I had a young man who committed a heinous crime, and he was 17. And by the time we came to trial, he was 18. They gave him natural life because he didn't accept the deal that I had set up for him. But the point of the matter is that they could not execute him. So that was the way it was in the state of Illinois. But in 2005, the Supreme Court said we will not. Now, let me say this to you. I don't know if that's going to change in the future because of the changes of the court and everything. And the reason why I'm saying that is because juvenile offenders are committing some very, very, very serious offenses, more and more and more. And since the time of 2005, there's been an increase in juvenile violent offenders. So we, and people that were juveniles being tried as adults. But let's just say it now and leave it right now, that the law of the land, and if you want to cite the case, Roper versus Simons, and then you could go ahead and you can look up what Roper versus Simons is, and it will give the exact citation to what it is. In fact, Roper versus Simons, I'm going to give it to you right now. It is, give me 1 second. Okay. Here we go. It is 543 U.S. 551. It was 2005. And that is Roper versus Simons. Okay. That's the citation there to the actual case. You might want to save that because it goes with some of your work this week. So anyway, so once and for all, it's settled. We don't execute juveniles, period, right now. Now, let's talk about the right of privacy. Oh, by the way, there are a few other cases that we discuss, and it comes up later in this course, but I'm just going to tell you now, because I think it might be an off week when I don't have a lecture, that regarding the death penalty, we also don't execute mentally ill people. And there's a whole debate and argument that's dealing with that. And the parallel is because of the state of mind of those individuals as well. So anyway, that's another issue, and it's a side issue. But you'd have to do some more research because that's ever-changing. But that's not what we have right now. Privacy. The sphere of intimate personal conduct is immune from legislative interference. In other words, the courts don't like to interfere in your personal conduct. And it has to do with the 9th Amendment, says that certain rights should not be construed because the people have a right to that, such as the Griswold case. Now, the Griswold case has nothing to do with Clark Griswold. Do you know about Clark Griswold? Do you know who Clark Griswold is? Who played the role of Clark Griswold? You ever heard of that one, Ann? Yeah, there we go. There we go. So it has nothing to do with that. It's known as, here it is right here, Griswold. Come on. Griswold versus Connecticut is where the Supreme Court struck down an attempt to control birth control. And this person was convicted for providing contraceptives to married people at this time, 1965. So the courts don't like to get into that because now they get into your bedrooms there, all right? And then they moved in 1972 to extend it in the Eisenstadt-Baird case to unmarried persons. where Baird was convicted for providing contraceptive foam to female students. So the court said, no, we're not getting into that. That's kind of the same issue that came about with this topic, abortion, which I won't spend a lot of time, Roe v. Wade, pro-life versus pro-choice. And you should know and be aware that there is a movement going on right now to try to overturn Roe v. Wade. As it is right now, it's the law of the land, and it specifies trimesters and all of that stuff, and I'm not going to go into that. The next slides cover that, but the viability of the fetus and those kind of things. So at this point in time, there is protection for the woman to be able to have the abortion based upon the circumstances that are listed in trimesters, first, second, third trimester, and so forth. Just by short is that the further you get into the pregnancy, the more government restraint there is on you having an abortion. There we go. That's it, period. So anyway, it involves pro-choice and pro-life, so I'm going to go past that. So finally, what has happened is that prior to 60, your government would get into your bedrooms and sexual morals, but after Roe versus Wade and Griswold, your privacy increased, so much to the point that it provided the prerequisites for the LGBT movement that took place, and then it says that's taking place now, and it was not until 2003 that the Supreme Court recognized the privacy right of LGBT, but now the law is totally in effect, because now there is marriage that takes place in LGBT situations based upon the Supreme Court decision. Lawrence versus Texas is where the Supreme Court held that the government may not criminalize adult sexual conduct. I mean, it's based on consent. And so in this case, Texas convicted a person for homosexual conduct, and then the court says, nope, but you know already that based on the way the law has changed, that is not the law of the land anymore at all. The right to die issue, you know, the whole issue about persons not pulling the plug and all those kind of issues, terminally ill, the equal protection clause. There are oftentimes instances where individuals are placed in those situations, and then there is a determination about whether to pull the plug and those kind of things. The one thing that we don't tolerate is assisted suicide. There was a Dr. Kevorkian who came out of Michigan years ago, who has passed away a long time ago. But Dr. Kevorkian was called Dr. Death, and Dr. Death used to do medically assisted suicides and provide prescriptions for people to kill themselves, or help people to kill their loved ones, take them out of their pain. But right now, that kind of issue is controlled by the courts, and oftentimes there is a guardian ad litem or attorney represented for the individual who can't speak for themselves. Of course, though, there are people who can sign what we call a DNR, do not resuscitate, and that individual is like a will to say that if they go into a coma or something, that the medical people can't attempt to save their lives, and then they just pass on. But that's that individual making that decision. And it's operated under the law of how the person's state of mind was at that particular time and all of that. So it's usually done before that person gets too far into the terminal illness. Equal protection of the law, which means the law applies equally to all people, period. And then the due process of the Fifth Amendment gives you the right to live your life without interference. Now, Bowling versus Sharp and Eisenstein versus Baird are older cases. But the one I always like to focus on, and this is one that they just recently did a movie called Loving. I don't even know if you're familiar with this movie, but It came out last year, I believe it was. It's now on DVD. Excellent movie, but it involves the Loving versus Virginia case. Are you familiar with the Loving versus Virginia case? Ann, have you ever heard of it? Have you ever heard of it? Interracial marriage, exactly. So here's the deal. Just what she said is that in this case, this was in 1967, which I found very interesting, that the United States Supreme Court had to rule that there was a state that said, and it was Virginia, that two people were convicted because they entered into an interracial marriage. The court said, no, that is, no, you can't do that. Concluded this law violated the Equal Protection Clause of the Constitution, which is, I mean, it's ludicrous, it's ridiculous, it's crazy anyway. But to me, what the crazy part about it was, I said, that was the law in that state. Well, that's an old, how should I say, holding on to the old Dixie that used to exist before the Civil War, and they were still on the books. And to believe that two people were prosecuted because interracial marriage took place, but that's all. That's old. And the unfortunate part about it, though, now, and I say this seriously because it's true, is that I know a lot of interracial couples, and they tell me still of some of the problems that they still have, not with the law, but to how people treat them, and that's a heart issue. That's an issue of the heart here. You can't legislate the heart, okay? That's a whole nother discussion, but you know what I'm talking about. But the fact of the matter is, people should have the right to fall in love and marry whomever they desire, period. That's the end of it. Judicial review is that rational basis test. Now, these are some tests that are used to look at the law, and depending on what kind of case it is. Rational basis test, and these are three tests that are used by the courts to deal with constitutional issues. The rational basis test very simply says it requires that the legislation, the law, must be rationally related to a legitimate government objective. Now, those kinds of things are really, you're dealing with things like, for example, the Patriot Act, or you're dealing with wiretapping, or you're dealing with some other laws that people feel that might violate our Fourth Amendment right to privacy. Then if there's a rational basis that the government has for those laws, then they might apply this. In a case of racial discrimination, fundamental rights, such as the First Amendment, will apply. Compelling government interest, again, the government must prove that the government interest is strong enough to override fundamental rights. Now, that's harder. So, in other words, rather than applying this, a fundamental right can be overridden, but the rational basis test is one that deals with race all the time. Like, for example, in that case that we just got to talking about, there's no legitimate government objective to saying that interracial marriage should not be the law of the land. There's no rational basis for it. And so anyway, these are different tests, and I'm not going to go into them in any detail. When I was in law school, we had a whole course where we dealt with these three tests. And so it is, but just enough to know, here's the key. The key is this, is that the closer you get the First Amendment rights, the easier it is for the court to protect those rights. But if there is some fundamental rights and there's a test or issue, then they might say, okay, you can have free speech, but it can't be obscene, it can't be incisive to incite a riot or something like that. It can't be along those things. So these are the three tests that are applied. So I'm not going to go deeply into them. It's a little after 10 now, and I'm going to be stopping in a minute. We don't get a chance to cover the two every week because of the fact that it's just so much material to cover in the lecture that I don't want to hold you longer than an hour and a half. So I'm just going to finish this one right here, which this is the end of it. The importance of state constitution. The highest court of each state possesses the authority to interpret. I already told you that. So, okay. So that's it for that. Now, as far as the chapter 4, I'm not gonna go into that. I'm not gonna lecture on that because I don't want to hold you any longer, because it would probably take me another half an hour to 45 minutes, and I don't want to impose upon the time of any of the students. So if you have any questions relating to that, what I will do is this, is I will go through and I will just show you that it pretty much deals with the mental state of crimes, such as the act of a crime and willfully committing. If you have any questions after this, going through it, feel free to reach out to me. So I'm not gonna go through this. It's about 25 slides. So any questions? Okay. And so, like I said again, if you have any issues about chapter 4 and I haven't covered them, actually that's why I give you the outline, so you can go over it. And you know, but there's nothing really earth-shattering in here. I already talked about Rasmussen versus California. I talked about status, crime, person being convicted. I talked about mens rea. Okay, this I'll just take a minute to talk about the state of mind and strict liability. There we go. That mens rea is different from the motive of the crime, and the prosecution must prove criminal intent. But in a strict liability crime, there is no requirement of mens rea. See, that's your discussion forum there. And then I'm not going to talk about this. Specific and general intent, I shared that with you earlier. And then there's more. Missed aim cases make a lot of sense. If you shoot at somebody and you miss them, you should be held responsible for the death of a person that's killed. They have what they call the felony murder rule that applies also in that, which it doesn't cover. Then these are the strict liability offenses, some of them. And then that. This is another case I won't go into. Strict liability, proximate cause. That goes back to what I said, that but for the fact that you fired a gun, a person wouldn't be dead. You know, here's a good one. I just want to, you know, I can't resist this because I always like to throw this out in this one. Emma is raped and left to die in an uninhabited area by John. Emma manages to crawl to the next street, and a truck driver picks her up and intends to drive her to the next hospital. But the truck driver causes an accident in which Emma dies. So the question is, does this meet the causation test? Here's the question. Who caused Emma's death? Was it John or the truck driver? What do you think? She would not have been there if it had not been for John. So are you saying that John is the one who's held responsible for that? Okay, the answer is no. And the reason is because there has to be a reasonable causation. Let me just back up a slide. Causation means that there exists a linkage between cause and effect. Well, for example, the gunshot caused the death. Okay, that's an immediate or approximate cause. But if there is an intervening cause, punishment will be likely to be different for the offender. So with that information now, you learn that actually, in reality, that Emma's death, yeah, it is. But it makes sense. It makes a whole lot of sense. Because John, yes, he raped her, says she wouldn't have been there, and that's the argument that a lot of students present. But we as lawyers know that but for the fact and cause, that's where people try to present the but-for argument, that if Emma hadn't have been raped, then the truck driver wouldn't have picked her up and taken her to the hospital and then not caused the accident. But could she have died from what John did? She could have, but she was alive and well enough, maybe traumatized, but he could be charged with rape, John could, but not with murder. So it wouldn't. So that's the whole point in a nutshell. So yeah, it is interesting, but it makes a whole lot of sense when you stop and think about it. Boy, if you ever become a defense attorney like I was, it makes a whole bunch of sense. And even to the prosecution, it makes a whole lot of sense. So what should John and the truck driver be charged with at all? Well, obviously, the truck driver is not going to be charged with murder, but the truck driver is going to be charged with probably negligence or whatever he caused the accident. But he's not going to be charged with murder, and he's definitely not going to have anything to do with rape. So maybe. It depends, because it doesn't say enough information. So, no, you're talking about the truck driver. Yeah, I know. But I'm saying you meant the truck driver. The answer is probably, I don't know, because there's not enough facts given here. It just says that he caused the accident. We don't know what he did. Maybe he was speeding. That could be. There's some arguments to that. But the point of the matter is that here's the issue, and the key thing is that is John held accountable for the actions of the truck driver? That's the key. Should he be held accountable for the actions of the truck driver? Yes or no? Yeah, exactly. That's why I'm taking the time to go over it. That is exactly. And it's easy as ABC. By the way, you'll discover that it's ABC throughout the whole quarter. Alan, Betty, and Charlie. ABC. Okay, that's what it's all about. So, but good tie-in. Excellent. But you're right. So those are the kind of things you think about there. Okay. So anyway, let's see. I don't think there's anything else. Accessories, we talked about that. I don't talk about accessories there. And that's it. So basically, Charlie was shot by David, but Alan and Betty were charged with murder. Here's the deal. The whole issue in a nutshell is that whenever all parties are involved in the crime, if one party dies, then the persons are collectively principals in the activities but for their activities. Remember, this was one action. This wasn't like the truck driver, which had nothing to do with the rape, but the fact that they were involved in committing a felony at the time, that causes them to be charged with murder, even if they didn't pull the trigger, but they were part of the activity. Now you got it? You got it? Now could you change something with something? That's it. What were you saying? Now could you charge David with David? Well, no, here's the deal. Who fired the shot? Who fired the shot? David, right? Okay, who was involved with the crime? Then they all going to be held responsible. Use this phrase here and look it up, and you'll know what I'm talking about. No, look at this phrase. I just gave you one. It's called the felony murder rule. You'll see what I'm talking about, okay? All right. So anyway, anything else? Okay. Well, I'm going to say good night, and I actually did cover the second one kind of in a perfunctory way because I had covered a lot of it earlier. But at any rate, remember our next lecture is not until week 4. However, each week I will still provide you with the PowerPoints. So, okay. So with that, I'm going to sign off and say good night. And thank you for coming out tonight. And I hope that I have more students to come out in the future. Thank you. So I'm going to end the meeting. Okay, I'm going to go back to the class and end the meeting. Good night.